Hello everyone, as you all are aware that we are daily posting videos on important case laws related MCQs. In furtherance of that, we have started making questions upon contract law. So this is the third video in the list of contract law. So let's get started. Question number 1. In the Nash versus Inman case, the issue was answer is A minus liability. Doctrine of unjust enrichment was laid down by the Supreme Court in which of the following cases? Correct answer is Maftalal Industries versus Union of India. The case Nash versus Inman 1908 is related to necessaries. Consider the following statements. Statement 1. Moses versus Macfarlane is a prominent example of theory of unjust enrichment as propounded by Lord Mansfield. According to this theory, the demands of justice and equity is to prevent the unjust enrichment of one person at the cost of another. Statement 3rd. Sinclair versus Borgham has propounded the theory of implied in fact contract to elaborate the nature of quasi-contracts. Choose the correct option below. All the statements 1, 2 and 3 are correct. State of West Bengal versus B.K. Mandal and Sons AIR 1962 SC 779 is an interpretation of which section of Indian Contract Act? Correct answer is section 70 of Indian Contract. Consider the following statement. Moses versus Macfarlane is a prominent example of theory of unjust enrichment as propounded by Lord Mansfield. According to this theory, the demands of justice and equity is to prevent the unjust enrichment of one person at the cost of another. Statement 3. Sinclair versus Borgham has propounded the theory of implied in fact contract to elaborate the nature of quasi-contract. Choose the correct option from the given below options 1, 2 and 3. This means that all the three statements are correct. Moses versus Macfarlane 1555 to 1774 is a case relating to a theory of unjust enrichment. The case of Hodgster versus De La Tour deals with anticipatory breach of contract. The case Frost versus Knight 1872 is related to anticipatory breach of contract. The principle of assessment of damages for breach is given in Hartley versus Baxendale. Hartley versus Baxendale is a leading case on remoteness of damages. The principle contained under section 73 of the Indian Contract Act is based on option A, Hartley versus Baxendale. Section 73 of the Indian Contract Act incorporate rules from which of the following cases? Correct answer is C, Hadley versus Baxendale. Match list 1 and list 2. List 1 says A, remoteness of damages, B, proof to loss to be given to claim special damages, C, loss of profit is special loss, D, consequences of delay in transit. Here the correct match for the particular question is A, remoteness of damage. The correct answer for this is Madras Railway Company versus Govind Rao. Correct match. Proof of loss to be given to claim special damages. Correct answer here is Chief Secretary of State of Gujarat versus Kothari and Associates. This is the correct match of B. Loss of profit is special loss. Here the correct answer is Krishan Das at Thakur versus Saran Engineering Company Limited. And D, consequences of delay in transit. Here the correct answer will the last remaining option, Union of India versus Steel Stockholders, where two parties have made a contract which one of them has broken. The damage which the other party ought to receive in respect of such breach should be such as may fairly and responsible be considered either arising naturally or responsible be supposed to have been in contemplation of both the parties at the time of entering into contract. This statement was laid down in the case of, here the correct answer is Hartley versus Baxendale. Concept that says unfair or unconscionable contracts or clauses should not be enforced is known as C, culpa in contrahendo. Which of the following is not correctly matched? Here the correct answer is, let us see the first entire option, coercion, Chikkam versus Ammiraju Chikkam Seshamma. This is the correct match. Liquidated damages, Dunlop Pneumatic Tire Company versus New Garage and Motor Company. This case is related to liquidated damages. Impossibility of performance, LOP Prasad and Sons versus Union of India. These all three are the correct statement. Question asks it which of the following is not correctly matched. So public policy, that is Hadley versus Baxendale, here it is given is not correctly matched, in which case it was held that the state government was in position of a bailee in relation of goods seized by its officers and was therefore bound to take reasonable care of the seized goods. Here the correct answer is State of Bombay versus Maimun Muhammad Haji Hassan. And which of the following judgments? A constitution bench of Supreme Court has held that the sale and installation of a lift is a work of contract. The correct answer is B. Cone Elevators India Limited versus State of Tamil Nadu. Match list 1 and list 2. List 1 suggests option A. Lalman Shukla versus Gauri Datta, B. McPherson versus Apanna, C. Banwari Lal versus Sudarshan Dayal, and D. MC Chaku versus Bank of Travancore. Now let us see the correct match in list 1 and list 2. So the option A, Lalman Shukla versus Gauri Dutt. Here the correct match will be general offer. In B, McPherson versus Apanna. The correct answer here will be invitation to offer. And C, Banwari Lal versus Sukhdarshan Dayal. Here the correct answer will be intention to create legal relationship. And the last and the remaining option, MC Chaco versus Bank of Travancore. So the correct answer will be first, privity of contract. Match list 1 and list 2 containing cases with list 2 containing respective areas of contract and select the correct answers using the code given below. List 1 says A. Balfour versus Balfour, C. Feldhaus versus Bentley, C. Krell versus Henry, and D. Harvey versus Facey. Let us find the correct match. A. Balfour versus Balfour. Here the correct answer will be intention to contract. And B. Feldhaus versus Bentley. Here the correct answer will be communication of acceptance to offerer. Correct option for C. Krell versus Henry is frustration of contract. The last option, Harvey versus Facey. In this, the correct answer is invitation to receive offer. Again, there is a question of match the following. Match the provision in the list 1 related with the cases in list 2 and select the correct answers using the codes given below. Let us read the statements of list 1. A. Statement of price is not an offer. B. Exception to privity of contract. C. Acceptance must be communicated to the offerer. And D. No estoppel against a minor. So here correct answer will be for A. Statement of price is not an offer. Correct answer is 3. Harvey versus Facey. And exception to the privity of contract, correct answer in this is Khwaja Muhammad Khan versus Hussaini Begum. And C. Acceptance must be communicated to the offerer. Here correct answer is Feldhaus versus Bindley. And no estoppel against a minor. Obviously the correct answer is Mohori Bibi versus Dharmodas Ghosh. Again the question is of match the following. List 1 says Lalman Shukla versus Gauri Datta, B. Tweddle versus Ettingson, C. Balfour versus Balfour, and D. Khan Gul versus Lakha Singh. Now let us match list 1 with the list 2. List 1, Lalman Shukla versus Gauri Datta. Here the correct answer is general offer. Tweddle versus Ettingson, B. The correct answer is privity of contract. And C. Balfour versus Balfour. Here the correct answer is intention to contract. And the last option, Khan Gul versus Lakha Singh. The remaining option, restitution, is the correct answer. Now let us again discuss the match the following. Question number 9. List 1 says invitation to offer, B. Anticipatory breach, C. Restitution, and D. Implied contract. The correct answer here will be for among list 1 and list 2. Option A, invitation to offer. The correct answer is Harvey versus Facey. Anticipatory breach, option B. The correct answer of anticipatory breach will be Rochester de la Tour. And for C, restitution, the correct answer for restitution is Leslie R Limited versus Shell. And for D, implied contract, the last and remaining option, Upton Rural District Council versus Powell. The correct match will be for implied contract. Now let us discuss the last question of this series. Match the following. Match list 1 and list 2 and select the answer by using the code given below the list. List 1 says A. Satyabrat Ghosh versus Magni Ram, B. Rajrani versus Prem Adib, and C. Entros Limited versus Miles for East Corporation, and D. Harvey versus Facey. As we all have discussed Harvey versus Facey lot many times, the answer for Harvey versus Facey is invitation to offer, option 1. And for A. Satyabrat Ghosh versus Magni Ram, the correct answer is doctrine of frustration. And then second, Raj Rani versus Prem Adib. Correct answer for B is 3, minus agreement. Raj Rani versus Prem Adib, minus agreement. And C, Entors Limited versus Miles for East Corporation. For C, the correct answer is communication of acceptance. And D, Harvey versus Facey, we have already discussed, is invitation to offer. And the remaining one, doctrine of frustration, here doctrine of frustration was discussed in Satyabrat Ghosh versus Magniram. So this is the last and concluding video of contract law related case laws. Again, we will meet with another case laws related MCQs. Please follow this series regularly and consistently. Thank you so much. Please like and subscribe us. Thank you so much for watching.